Hello everybody, it's Rick. It is Saturday, May 14th, 2022. As you see here, if you're interested in receiving my paperwork in exchange for a gift, my email is rick0327@me.com. Please, I don't speak on the phone, I'm sorry. As you can see, read here, I provide court affidavits, approximately 60, also to send the child support agency, to send the DMV, if your license is suspended, to send to the State Department, if your passport has been frozen, to send the credit agency to fix your credit. Okay, I make no guarantees. No, you can't make any guarantees. We're dealing with serious fraudsters. All right, I do not work personally with you, but you know, after you send me a gift, and for an additional gift, I can, you know, help pick out the paperwork for you. All right, keep the emails very brief, and please, I don't respond to long emails, please. Okay. All right. Oh, I got good news. I got another subscriber who went to court, filed the paperwork, said the right things, and as he said, case over. Thank you for your paperwork. I cannot believe it worked, but it did. I did what you told me. I filed the paperwork, and when I went to the hearing, all I kept saying was my paperwork is my testimony, and I do not consent to these proceedings. The hearing officer kept trying to get me to talk and demanded my taxes and pay stubs, and I responded, I do not consent. And when will a court answer my paperwork? So that's another thing that's good you could do, is you get the court on the defensive, because, you know, a lot of times they don't respond to the paperwork. Okay, so you go to the trouble of filing all this paperwork, and they don't want to respond because they cannot respond. This is just a game for them. Okay, it's a game where they're going to intimidate you, and a lot of times you go to court because we're all, you know, programmed thinking that they have some power over us, and they don't. They have no authority over us. Okay, the only thing they got going for them is they have, you know, a deputy or a court officer in there with a gun and handcuffs. Okay, so, you know, just stand your ground. Just say, I don't respond. Okay, anyway, the hearing officer ignored me and told me to leave the room. I waited outside. After 10 minutes, my ex came out looking pissed off, and the deputy came over to me and said, your case is over, and smiled at me and said, I don't know what you wrote, but it worked. And don't have to come back, and that you will receive the papers in the mail. Okay, anyway, you can read the rest, all right? Bottom line is this case is over, and he filed the paperwork before going to court, all right? And it was my paperwork, okay? I have good paperwork. I have really good paperwork. Okay, yesterday I received another email from somebody who probably contact with a guy who's selling my paperwork. Listen, you're better off getting the paperwork for me because it's my paperwork. Okay, I wrote it. It came from here. I didn't copy anybody's paperwork. All right, and my paperwork is really good. All right. Okay, so you're gonna go to, if you have my paperwork and you're preparing to appear for child support legal proceedings, what paperwork should you file? Well, the first thing you should file is a notice of rebuttal that you're not a person. Okay, you are not a person. You are a man. Okay. Then you're gonna file a dismissal, non-assumpsit, contesting personal jurisdiction. Non-assumpsit is what you're saying is that you did not enter into a contract with them. Okay. Dismissal, non-assumpsit, means that you did not enter into a contract with the child support agency. And they must provide evidence that you did. Okay? You're going to send a notice to the clerk of the court That's affidavit 1B, to provide evidence of an injury in fact, or you will file a default judgment. Okay. Now, for the people out there that have my paperwork, I switched this around a little bit. So if you're looking at it and you go, oh, I don't know, my 1A doesn't say that, and the notice of rebuttal, I'm not a person. I just added that recently. Okay. And I also mixed them around. So don't get all crazy. You know, you have most of these affidavits. Okay. Notice of acceptance of oath of office. What you're doing there is you're telling the judge or whoever is, you know, officiating or administering the hearing that you're accepting their oath of office. That they're basically when you accept their oath of office, what you're saying is you're holding them to their oath that they're gonna defend the Constitution and the Bill of Rights. Okay? So by doing that, you're telling them that if you're not doing that, that you are acting, you know, without jurisdiction. You're acting without authority. They only have authority to support the Constitution. Anytime they act outside the oath of office, okay, they're acting unlawfully. It's that simple. Okay? And there are ways of getting their bond. They all have bonds. There's insurance bonds that insure them that they're going to adhere to their oath. And that's what the insurance bond is for. It's very hard to find, though. They hide these things. And they don't give it up. All right? But, you know, there's a lot of insurance companies. Just Google, you know, how do I find a bond for a public official? Okay, I did a little research on this, and there are a lot of insurance agencies like Travelers, and there's other agencies out there. And listen, if you got the patience, call them up, ask them if they have so and so name, that, you know, whoever you're dealing with, and maybe you get lucky. And then you can file a claim against their bond. Okay, so 1F is a notice of motion for objection. I'm sorry, 1F is a notice of motion for objection, demand for dismissal without prejudice, for the defendant cannot be forced to participate in a legal process, for it is a crime of forced labor. Okay? Interrogatories. What you're doing is you're demanding. I did a video on this a few weeks ago. What you're doing is you're demanding discovery of evidence, discovery of a record, which means information that is inscribed on a tangible medium or that is stored in an electronic or other medium. Okay, it's a fancy definition under 45 CFR 301. Okay, and what you're doing is with the interrogatories, if they don't respond, you can file a default. Okay. Now, if you do not plan on appearing personally, okay, or for a Zoom hearing, what you could do is you could file paperwork that, again, notice of rebuttal, I'm not a person. Also, again, 1A, dismissal of a non-assumpsit. 1B, to the clerk of the court to provide evidence of an injury in fact. A lot of times, these clerks, they just file these applications / petition, and without any evidence, you know, you're being accused of, you know, of not paying support. Well, they're supposed to provide evidence. That's the way it works. For a plaintiff to have standing, they have to provide evidence. So you're going to send to the clerk a demand for evidence of what they accepted before issuing the petition. Okay. 1C is notice to the court that you are refusing to appear voluntarily and that you do not accept the offer to contract and you do not consent to the proceedings. Okay? What you're telling them is that you're not showing up and you're giving them the lawful reasons why. 1F is a notice of motion for objection, demand for dismissal without prejudice for the defendant. You cannot be forced to participate in a legal process. Okay, a legal process is voluntary. They don't want you to notice. That's why they threaten you with arrest. They threaten you with suspension of your driver's license. And I did a video on it. These are psychological tricks. Okay, that's what they are. To get you intimidated. Okay? Okay, what do you do if you file, and if the court does not respond? You have affidavit 1E, it's formally 1D, so many of you have 1D. Okay, it's a default judgment under Federal Rule 55, or look up in your state law equivalent, meaning in your state, what is the law for a default judgment. Okay, and then what you're going to do is, with the default judgment, you're going to attach the paperwork that you filed or you sent to the child support agency, and you submit it with the default judgment saying that they didn't respond in a timely manner. Let's say you told them, you gave them 10 days, they didn't respond. You're filing a default judgment, a dismissal with a default judgment. Okay? Because that's what they do. They hold you in contempt and default judgment if you didn't show up. Meanwhile, they never established personal jurisdiction over you. Okay? And then you're on the defensive. Okay? All right? If you're filing a default judgment, file it in a county court, and you're going to be the plaintiff, and the child support court and the child support agency, usually one of the same, but they're going to be the defendants, okay? And the reason why the court must accept the default judgment is because it is the duty of courts to be watchful for the constitutional rights of the citizen and against any stealthy encroachments. This is a nice definition, but try to avoid calling yourself a citizen. Just stick to calling yourself a man or woman or one of the people. Try not to refer to yourself as a person or a citizen. Okay, it's just good practice. All right, and that's basically it. All right, this is just a real quick video, just if you have my paperwork, what to file, give you an idea, what direction you're going, what you're doing is, you want to establish, you want to get the court on the defensive right away. Okay, it worked. I just showed you it worked for for somebody, so it can work for you too. All right. I'll talk to you guys soon. Bye.